Hey, everybody. Welcome to True Crime Wednesday. Great to see everybody. I'm a little disorganized today, so y'all are going to have to bear with me. It's been a really busy week for a lot of great reasons, but I'm not as prepared as I like to be. Just giving you that warning right now, and I'll fill you all in once a few more people join. So, but got a lot to talk about today. We've got a few developments in Sarah Boone's case, a little bit on Adelson, a little bit on Delphi, and some fairly big news on Kohberger that we're really going to kind of dive into and take a look at. So I'm glad you're all here and welcome. Great to see everybody. Do post your questions with Q's, with capital Q's in front of it for Jen. We are going to answer some questions. We probably won't go as long as we usually do tonight because I've got a lot on. So, but it's great to see everybody. Let me just fill you in a little bit. It's been kind of a busy week for me. This whole retirement thing, you get busy in retirement. So, not anything huge. I've been running around trying to get my mom lined up with some of her new medical providers. So I've been busy with her all week, and then there's just been a lot going on with the book and with my publisher. So that has kept me sort of tied to my computer and fielding emails. It's all good news. We've got several book signings coming up. The publicist from Pegasus Books has been doing a bang up job, and she's got all kinds of fun things lined up and a few more things that we're waiting to hear on. So, but the exciting news is that I will be at Powell's Books in Portland, Oregon, at the Cedar Hills location, for all of you that are familiar with the Portland area. Doing a book signing on September 26th. And that I think starts at 7 o'clock. You can find all of the details on Powell's Books website. Now, I am going to put out a post with all these dates and the links to all the sites so that if you are interested, you can join us. I also have a date in Bend for anybody who's here in Bend. And that's on October 10th at Roundabout Books. That's out on the northwest side of Bend. But there's some other exciting things going on. We're working on a partnership with Rediscovered Books in Boise, which is the independent bookstore in downtown Boise, for some dates, as well as Barn Owl Books in McCall, Idaho. For those of you who might remember, I went to McCall just before we moved, so in July-ish, and had a great weekend up there with some of the ladies who are our fans, and had a great weekend there doing a little kayaking, a little boating, and met some folks from up there who suggested that I reach out to Barn Owl Books because they would love to have me. So I'm going to be doing that. I'm also trying to line it up so that I'm making one trip to Idaho and can do Boise as well. That looks promising, so I'm waiting to hear back on firming up those dates. I also have a date in Ashland, Oregon, which is where the Shakespearean Festival is, and is this amazing Southern Valley town in Oregon. And we're still working on a few more. There's some other things that may be in the wings, so look for more information. And it's just been a really exciting, fun time. I also was having a conversation with my agent, who told me that he's already been talking with potential publishers for the next book. So I'm working on a book proposal for the next book, and which I will fill you all in as we go along. It's really a fun kind of as fun as true crime could be. A little bit different take on a couple of cases. So I'm looking forward to that. I wanted to talk a little bit, first of all, about Sarah Boone. Now, y'all know Sarah Boone has a new lawyer. He initially said that he had some sort of an agreement that eventually, possibly, Sarah would pay him. He now has sort of backtracked on that and said he is pro bono. That is likely because um, she is indigent and it has to do with getting the state to pay for experts in and other expenses associated with her trial. So they filed a notice. You might remember at the last hearing, Sarah's attorney was um, complaining about the fact he wanted extra time because they had to file their notice of intent to use a defense, the battered spouse defense, within 30 days of the trial. So he had to do that by September 3rd, I think, or 7th. I can't remember. But that had to be filed. And the judge said, no, you don't get any extra time. So he had to file that, even though, sorry, we still have smoke here, although it's getting much better. We had rain all day today, which was very welcome. Welcome for the firefighters that are out fighting the wildfires, the wildland fires. Also welcome for those of us who are suffering with the allergies and the smoke related stuff. So he had to file, Sarah's attorney, Owen, had to file that notice, even though he had not yet had all the evaluations that he was hoping to get prior to trial. The prosecution has filed an objection to those to that notice and is saying that they don't want them to be able to use that in their opening statements because they haven't done any preliminary evidentiary hearings. So before they can present that defense, they have to present the fact that they have to present evidence that there is a creditable argument that Sarah was a victim of domestic violence and battered women defense. I'm trying to get rid of this because it makes my other screen here glows until I can't see and you can't see. But I thought it was interesting that they are asking that there be limitations on what they can say in opening statements because the judge will not have ruled whether or not that evidence will come in, whether those experts are experts for the purpose of the trial. So they've filed motions in limine asking the judge to not allow. First of all, they filed a motion in limine saying they don't want Sarah to be able to use that defense at all. But if the judge doesn't grant their motion, they want Sarah to not be able to make that argument until after the judge decides those evidentiary rules. So they don't want her to be able to bring that up in opening statements. That's a little tough. But what the defense could do is they could reserve their opening statement until after the prosecution rests. So there's the possibility of doing that. And then in the meantime, getting those evidentiary rulings ahead of time. So we'll see how that plays out. But the prosecution's definitely pushing back against Sarah making that allegation. It's a very, very tough, really tough argument to make based on the evidence at hand. I heard somebody say, another creator say, it would have been a better argument if she had said, well, we were into kind of bondage games, and I put him in the suitcase and he didn't use his safe word, and I didn't realize that he was being serious. And I mean, that kind of an argument might have been a better way to sort of show that it was not intentional than what she is talking about now. So they're trying to justify um, her justify the video, which is very difficult. If you haven't seen the video, after he was zipped in the suitcase, she made a video in which she was clearly drunk. She was slurring her words, but she was taunting him. And he was saying, "I can't breathe," and she was saying, "Well, that's the way I feel when you cheat on me. That's so sorry, too bad," kind of. At one point, she did say, "That's the way I feel when you choke me," but that's really the only connection to any sort of domestic violence. Now, if you want to watch that, it is in our show notes. The link is in our show notes. Be warned, it is very hard to watch. You see the suitcase moving around. You can hear his voice as he's trying to communicate to her that he is in distress. And she's taunting him and ignoring him. So it's hard to watch. So I anticipate that there will be some evidentiary hearings coming up in advance of Sarah's trial, which is coming up pretty quickly. Donna Adelson's trial is coming up next week. And there have been some new developments, although I don't, they're filing motions fast and furious in that one. Apparently, there are messages through the WhatsApp app between Charlie and Donna that we haven't seen before. That may possibly have been since Charlie's been in prison, but no one really knows. Because right now, what they're fighting over is what expert can come in and testify about how those were obtained and where they came from, and sort of do the chain of custody on those text messages. So we're waiting to hear on that. Both Charlie is in North Dakota, where he is being housed because of security issues in Florida. And he's going to have to be returned to come back to testify in Donna's trial. So I'm sure that's underway. Catherine Magbanawa and let me see, not Luis, Sigfredo, are both being moved from prison to Tallahassee jail because they'll be called as witnesses as well. The judge denied the request to change the courtroom to a smaller courtroom because they felt like it was, the public was sort of, there was too much public. People were tweeting, people may have been taking pictures of things that were on the defense desk. And the judge just said, no, I'll do my best to control the courtroom and the gallery, but we're not moving to a smaller courtroom. So we're not going to diminish the public's ability to attend the trial. I thought about going down there, but I'm just not in a place right now where I can do that with everything else going on in my world. So other good news going on in my world, my daughter and son-in-law are looking hard for a rental property for a house in Bend, and hoping to be moved up from the LA area in mid October. Yeah, middle of next month. So that's exciting. We haven't lived in the same area in a very long time with our daughter, so we're excited to have her close. And but in the midst of trying to get ready for today, I had to run over to Bend and look at a rental house, helping them out do a little bit of scoping out for properties since they're in LA. So, but Adelson is going to be a really interesting trial. There are going to be a lot of moving parts going on that one. It is going to be really interesting to see how that plays out and whether there is new information. One of the things that the defense has tried to keep out is the evidence of their flight to Vietnam, and because they don't want the jury instruction that says you can presume that flight is consciousness of guilt. And so they're fighting hard to try and keep that out. I don't think it stays out. I think it comes in clearly as consciousness of guilt. And I just do not see how the defense argues that it's not relevant, or that it's overly prejudicial, or that it's not probative, or, I just don't think they get there with what was so clearly, if you look at all the text messages, and Donna's talking about getting all her affairs in order and having Wendy come over and look at documents and all those things. I just don't think you get around the fact that they clearly were leaving town before they got arrested, or at least before Donna got arrested. So there have been a couple of developments in the Delphi case. I'm sure that you all have heard by now that the judge denied once again. Actually, what happened was the prosecution filed a motion in limine wanting the judge to keep out any suggestion of a third-party culprit, and also wanting the judge to keep out all of the information about the geofencing that happened around the time of the girls' murders. The judge ruled that she was not going to allow them to present the Odinist theory and the theory of a third party. She was not going to allow them to present the geofencing. Now, for the uninitiated, geofencing is when they send a warrant to a particular owner of a cell tower or a particular carrier, and they say, I want to know all of the telephones or mobile devices that were within this radius of this place at this time. And so they have now said that they're not going to allow the geofencing. I was just looking here to see what Jen was just posting about geofencing. A virtual geographical boundary triggers a marketing action. Yeah. So what they can do, they did the same thing in the Vallow-Daybell case. They created a virtual boundary around the property and then said, I want to know all of the phones that come in and out or came in and out during this period of time within this geographic location. So that's what they did with Delphi, and they turned up a couple of suspicious numbers around the time that they think Abby and Libby died, although they do not have a clear picture of what time the murders actually occurred. So those are two really, really big blows to the defense. And as a result, the defense has now asked the court for leave to file an interlocutory appeal. Now, we've seen interlocutory appeals before. So let's talk a little bit about what that is. In most cases, you cannot appeal a judge's ruling until the case is over, until there is a final judgment. So you can't appeal until the case is run through the trial court and is finalized. But there are some instances where the court says, we believe, or the law says, that there are some instances where prejudice would arise if they were not allowed to go forward with this, with an appeal on a judge's, say, evidentiary ruling or something like that pre-trial. So we saw interlocutory appeals. I'm trying to remember which case. But in this case, after the defense attorneys were Judge Gull tossed them off the case, they filed what is called an original action with the appeals court. They had to do that because they didn't have legal standing as his attorneys in the underlying case. So that was a little bit different procedurally. But now what they're saying is, Judge Gull, we don't agree with your ruling. We think that there would be undue prejudice to our client if we have to wait until the whole trial is over to appeal your ruling. And so we want leave to appeal the ruling to the appeals court. I think Judge Gull's going to deny it, and they're going to have to then appeal directly to the Supreme Court. What that means is that it's unlikely that Richard Allen is going to go to trial in October. Because if the Illinois Supreme Court, Indiana Supreme Court grants leave for them to review Judge Gull's ruling, that could take a while and certainly would require there to be briefs filed and oral arguments taken. So I don't think it's anything that would happen quickly, and that probably is going to mean that the trial would be delayed. It's likely, I think, that Judge Gull, if we know anything about Judge Gull, will continue to deny their motion and will just let things work their way out through the appeals court. It's hard to understand how a judge gets away with being so obviously biased against a defendant, and I mean, who so very clearly is tipping the scales of justice against Richard Allen. It's hard to understand why the Supreme Court doesn't say, this just doesn't look right. And that may very well be what happens if they continue this interlocutory appeal. So we can keep our fingers crossed that that's going to happen. But I would say with this filing, I'm doubtful that they will that they'll get to trial in October as originally planned. So before I pop over to Kohberger, I did want to kind of go through our list of upcoming trials on my hot pink sticky notes and talk a little bit about what might be coming up. Now, we had Dee Warner. That was a preliminary hearing, and the judge found that there was sufficient evidence to bind him over for trial, but I don't know that a trial date has been determined. Lindsay Shiver was, that one was planned for October, but I understand it is possible that it has been delayed again. That's the one in the Bahamas. Then we have Brian Walsh. Brian Walsh is coming up on a motion, on a whole stack of motion hearings. And we just learned that now, for those of you who might not be aware, Brian Walsh, his case is in Massachusetts, and so is Karen Reed's. And in the Karen Reed case, and so is the Sarah Birchmore case, all within the same area. And Michael Proctor, who was the very problematic Massachusetts state trooper who was the lead investigator in the Reed case, was also the lead investigator for the Walsh case. I saw that it appears that the state is not going to call Michael Proctor, and he is now on unpaid leave while they investigate his continued misconduct. So I think that any case that Michael Proctor is associated with is going to receive very close scrutiny going forward. And so I think we're going to see a lot of cases that are going to suffer as a result. Sandra Birchmore's case is moving forward. Farwell, I guess is the way it's pronounced. He's in jail, and that one is moving forward. I did see a statement that her family is very grateful that after they had the second opinion on the medical examiner, now the FBI has come in and taken that case over. It is federal charges because it is misconduct by law enforcement officers. So they have federal jurisdiction. So, and that is good because that takes it once again out of that Massachusetts, Boston, and suburban Boston jurisdiction that has been so problematic in Reed. The Canton Police Department, Birchmore was the Stoughton Police Department, and they are another Boston suburb. And because it involved a police officer, the Canton police were the ones who were in charge of that investigation. Well, we all know the Canton Police Department are pretty problematic on their own. So, so that was that's going to. I think what's going to be most interesting is to see those cases with Michael Proctor play out and how the state is and the commonwealths are going to deal with the fact that they have what appears to be at a minimum a sloppy cop and potentially a dirty cop. So we talked about Delphi, that's scheduled for the 15th of October through the end of the month. I have my doubts whether that will go because I think there are going to be continued appeals on Judge Gull. And then on the 22nd of October, we have Ashley Benefield's sentencing. In December, we have James Craig on the 2nd of December. And then in January, we have the Reed retrial and Larry Millette. So we'll have some interesting things to talk about coming up. And of course, we have lots of other cases out there. I know that some people have been following the case. Is it Schaffer? The case where the mother is claiming that her 7-year-old daughter was responsible for the murder of her husband, and then she just hid his body under a cement slab in the basement. That one has been going on this week. I have a real problem with a mom who is willing to throw her own child under the bus. I mean, is it outside the realm of possibility that the child witnessed domestic violence and was trying to protect her mom and shot her dad? It's not outside the realm of possibilities. But you would think if that were the case, the first thing she would do would be to call police and say, oh my God, here's what happened. And the child would be standing there and able to confirm that. Instead, apparently, she buried his body and then laid a concrete slab on top of it. That to me sort of smacks of if I hang this on my daughter, she's a minor and she's barely out of being a baby, and won't face any consequences. And I find that very, very troubling. I sincerely hope that the court is taking a hard look at that and is really trying to get to the truth. Her name is Laurie, Laurie Shaver. Um, and she's on trial and blaming her child. We also still have the endless YSL RICO case going on. And I just do not know how the prosecution could look any worse than they do in this trial. Um, this is Fonnie Willis in Atlanta, Georgia. She is also the prosecutor who decided to prosecute Donald Trump for voter fraud or trying to influence voter. Uh, I don't even quite know what the charges are, but have to do with it, Donald Trump trying to pressure the person in charge of elections to find more votes, basically. Several other people have already been prosecuted, have been pled out in that case. And but as a result, because Donald Trump has a lot of money and a lot of lawyers, they went after Fonnie Willis personally. So then there was this big furor about whether or not she was in a relationship with a man that she hired to be a special prosecutor on the Trump case. And so there were hearings about that. It was all very unpleasant and untoward, and really, tarnished her reputation. There's also been other challenges to her management, her leadership style, her decision making, and all of that sort of then pours downhill to all the other cases. And you add to that the fact that these prosecutors, I don't believe are trustworthy. I think they've been withholding discovery from the beginning, and I think that they are trying to make this case look like what they want it to look like. It is a RICO case, and the allegations are that this organization that was a rap record label was also a gang, and that they are responsible for at least the murder of one rival gang member. You might recall Woody, I think it's Thompson, was on the, or Coleman, I think, was on the stand for days and days and days, and it was theater. It really wasn't a courtroom. And through a Young Thug, who is the main defendant, his attorney was thrown in jail for challenging the judge on an ex parte hearing, and held in contempt of thrown in jail. The judge was then recused because he was clearly biased. And so, I mean, it has been one circus after another. I mean, every time you tune in, you think, wait, can I hear Calliope music? Da, 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 da. And I mean, first of all, they're prosecuting, I think it's 6 defendants. So anytime you have 6 defendants, 6 attorney teams for each of the defendants, and mountains of evidence having to do with this record label, the process is going to get bogged down anyway, because there's just so many people involved. So it it continues. That case has been going on for something like 18 months. It's been well over 100 days of trial, and they still can't seem to make a lot of progress on it. So that one is really it, it is bordering on the absurd at this point. So lastly, before we take questions, I do want to chat about Kohberger, because there was a lot going on in the Kohberger case. The biggest decision was that the judge has ordered a change of venue. So I want to talk a little bit about it, because you guys all want to know about the legal stuff. So the judge, there was a hearing, and at that hearing, the defense presented several really compelling witnesses. They presented the CEO of the company that did the survey work, and did some of the analysis. They presented a jury expert. They presented a human behavior specialist who was particularly interesting. If you have not had a chance to listen to that hearing, I thought she was really interesting. She made a lot of really good points about the way that we perceive information and the way that we form opinions. And it made a lot of sense in reference to how jurors form their opinions and how we form our opinions about media and about what we hear. So I thought she did a really good job, and she had a lot of really compelling things to say about how potential jurors could be receiving this barrage of media. So in Idaho, there's a couple of different ways that a judge can get to a change of venue. There's, first of all, definite prejudice, a proven prejudice. Now, usually the way that happens is you call in a bunch of potential jurors, you do a whole lengthy voir dire, you discover that nobody on the jury panel can be fair, and then you say to the judge, "Judge, we need to change your venue because it's clear that these folks have had too much exposure to this case, and they can't be objective and fair. They can't be unbiased." So that's the first way. But then we have the way, which also was the way that that Judge Boyce in the Valladay-Bell trial justified a change of venue, and that is a presumed prejudice. So what it means is looking at all of the media coverage and the information that has been put out about this case, can we presume that there is prejudice? And that is what the defense was relying on, saying, look at all this information. 96% of the population have heard about the case. And in a jurisdiction as small as Moscow, we have additional trouble. We have the fact that it's very likely that prospective jurors coming in know somebody who was involved in the investigation, or know somebody that was involved with the school, or knew the students, or knew the landlord, or any number of things. They also said there's always the chance that because the sentiment is so clearly against Brian Kohberger, that jurors would feel like if they feel like there's reasonable doubt, they would not feel comfortable in their community coming back with a not guilty verdict. that they would feel like that might ostracize them, or they might be fearful if they were to come back with a not guilty verdict. So the judge decided there was presumed prejudice. He definitely took note of the fact that the prosecution didn't present any information or any witnesses. They just argued, but they didn't have anything to back up their arguments, unlike the defense, who had some very impressive witnesses. Now, the judge's ruling was issued and is out there floating around, and he does go through each one of the witnesses and the parts of their testimony that he found particularly persuasive. So that's out there for anybody who wants to dive deep into that. So the other issue that the judge brought up was the issue of convenience. So there is a line in the statute that says if a different forum would be more convenient to the court, the witnesses, anybody involved in the trial. What the judge pointed out, and the case law also indicates, is that it's not just a matter of whether or not Moscow is convenient. It is also a matter of whether the court and the county can support a trial of that magnitude. And Judge pointed out that the resources in Moscow are very limited. There's only one court clerk, and that court clerk would have to be tied up in a 3-month trial. There are a limited number of court security officers, so they would have to bring in people either from the state police or from Moscow PD. Both of those organizations are understaffed, so trying to bring in somebody else to bolster the court security and the sheriff would be counterproductive, because it would just be sort of taking an already scarce resource and moving it over here. The judge also pointed out that the size of the courthouse, that they don't have a courtroom that would accommodate the size of crowds that they expect. They also don't have a jury room that would accommodate 18 jurors, so 12 jurors plus 6 alternates, which is what they had for Vallow Daybell. So the judge said the sheer logistics of trying to get to have this trial in Moscow is really overwhelming. There's no place within the courthouse for the defense to have space to work. The prosecutor's office is in the building where the courthouse is, but they would have to find a place for the defense to work. And that would mean taking over probably the county hearing chamber. There just are a tremendous amount of limitations in the physical space of the courthouse, as well as the staffing. So for that reason, the judge said he was going to grant a change of venue. Now, when that happens, we saw this with Vallow and Daybell. The judge has a couple of different options. The trial judge cannot decide where the trial moves to. That is up to the Supreme Court and the Chief Justice of the Supreme Court in Idaho that makes that decision. But the judge does have a decision to make about whether he will stay on the case or not. Because the statute says that the judge who grants the change of venue can either stay on the case and move with it to wherever the change of venue will be, whatever jurisdiction is going to receive the trial, as we saw with Judge Boyce. Judge Boyce opted to stay on the case and to follow it to Boise. The other option is to ask the court, when they determine where venue was going to be, to also appoint a judge. This is the option that Judge John Judge from Moscow, from Latah County, opted for. So he has determined that he does not want to follow the case to Boise, which we're presuming it will be in Boise. The Ada County Courthouse did a phenomenal job during both Vallow and Daybell's cases. And they have practice and they have this down. And so it makes a tremendous amount of sense to move the trial to the biggest jurisdiction. They have the physical space, they have the staff, they have the experience to pull it all together. So it's likely that it'll be in Ada County, but that is a decision that the Supreme Court, the Chief Justice of the Supreme Court, will make. Presuming that it will be in Ada County, then the Supreme Court is going to have to make a decision whether to just say, Ada County, you need to appoint whatever judge is next in the rotation for a death penalty case. Or the court could say, we're going to bring in a special judge, like we saw in Delphi. And what that means is we're going to appoint a judge. Usually it's a senior judge, a judge who may be retired from the bench, but still, in many jurisdictions, what happens is judges can retire at their earliest retirement date, but then they agree to come back and serve so many days a year as a senior judge. That gives the judiciary a pool of judges to pull from to backfill judicial assignments when a judge, like when Judge Boyce got sent to Boise for the Vallow and Daybell cases. Well, he's the only judge in that. There's one judge and one magistrate in that county. So when that happened, they had to bring in a judge to fill in for him in Fremont County while he was in Boise on both those trials. So it gives the state a pool of judges to pull from when to backfill in cases like that and in just basically like vacation cases. They're also the judges who cover cases if there is a conflict. Now, in smaller communities like the one I used to practice in, sometimes what happens is you have someone who is regularly involved in the court system, say they're another lawyer, and they're getting divorced, and they need a judge to preside over a family law matter or a probate matter. Well, in that case, because this is a lawyer who appears regularly in front of the bench in their county, those judges cannot make a decision on behalf of that lawyer. It's a conflict. So in that case, they would bring out in an outside judge from a different county who would come and sit on that particular case. What generally happens is they put all those cases together, and that judge comes in and spends several days and might hear other cases and sort of help catch up with backlog, and then would hear those particular cases that the bench is conflicted out on. So that pool of judges could be somebody that the Supreme Court would pull from to find someone to manage the case. It would make a certain amount of sense because then that judge could devote all their time. They wouldn't be also hearing other matters in other places that would be their only case. So we'll have to wait to see what the Idaho Supreme Court, the Chief Justice, is going to do and where that means that the case will be. I think that there is a 99% chance that it goes to Ada County, to Boise. And I think right now it's sort of a flip of a coin whether or not the judge will just ask whoever's up in the rotation to be assigned or out of Ada County, or whether they would assign a special judge. If you remember, Judge Gull was a special judge. She in Delphi. She came from a different county, and was appointed to hear the Delphi case. So she's actually the chief judge in another county. So there are a number of other motions that have been filed in the Kohberger case. I think I counted about 8 or 9 different motions. Those will need to be heard by whoever the new judge is going to be. And there are a number of kind of pro forma motions. I think they're smart motions to file, but a lot of them have to do with a motion to strike the death penalty, a motion to strike the aggravating factors that make it a death penalty case, a motion to, I gotta look at my notes here. There were motions to get rid of some of the aggravating factors, like the utter disregard factor. There were motions to strike the death penalty, motions to strike the state's death penalty notice, notice to strike the notice of the death penalty because of international law. International law has absolutely holds no sway over US law, but it makes perfect sense for them to do these. The reason it does is because death penalty lawyers know that in a lot of ways they're playing a long game. And that long game means that they file all of these motions. You could say they throw it against the wall and see what sticks. And sometimes nothing sticks. Sometimes they win a minor little victory. And what they're doing is over time, they're pecking away at the underpinnings of the death penalty. So, and that is sort of a national effort. Many of these attorneys, in fact, probably all of them, belong to the American Bar Association's death penalty committee, and belong to other organizations, national organizations focusing on the defense of the death penalty. And they really do strategize about bringing motions in death penalty cases, both to benefit the individual defendant. So in Brian Kohberger's case, they're filing motions both to benefit Brian Kohberger, but also to continue to try and push the boundaries, expand the envelope of death penalty practice. So it's furthering trying to make new law. And, what doesn't work in a death penalty case in Idaho, that same argument might work in Indiana, or it might work in North Dakota. And making those small inroads sort of tinks away at the foundation. And that's what they are doing. So John Pryor filed some of these kinds of motions in Chad Daybell's case. Archibald and Thomas filed some of those kind of motions in the Vallow case. But Ann Taylor is an incredibly experienced and very good criminal defense lawyer. And she is a very good death penalty lawyer. And she is going to double dot every I and double cross every T. And that means that she has her team working on every possible motion that they can bring. So we're going to see a lot of motion practice. Now, remember that this case is very unlikely to go to trial before the summer, maybe even the summer of 2026, depending on what Ada County can accommodate, and a lot of other pretrial issues that have yet to be decided, yet to be pled even. So I don't know that we're going to see a trial in Kohberger before maybe early 2026. Initially, the court was talking about summer of 2025, but that was when the case was going to be in Moscow. So it's going to it is going to take the Supreme Court making a ruling as to where the case is going to be, and then that court having a discussion with Latah County and if it's Ada County, it's going to be a discussion on when they can accommodate another high-profile case like Vallow and Daybell. I suspect that Kohberger is going to be even more. We're going to see even more scrutiny on the Kohberger case, even bigger crowds. We're going to see even bigger media outlets because of the fact that because of the victims. So I think that's coming, but I don't think we're going to. If I had to guess, I would say 2026 sometime. So I think we're about ready to take some questions. As I told you, I'm not gonna go quite as long as usual tonight because I still have to pack because I'm going to Vegas. I think I told folks earlier on I am headed out in the morning to spend a few days in Vegas with my daughter and son-in-law and son-in-law's mom. My daughter and I are going to go to the Pink concert. I've had tickets for months to go to see a performance. I hear that her performances are incredible, and we're going to spend a little more time in Las Vegas, and then I'm going to go back to spend some time in the LA area, and so I'm gonna be gone about a week. There will be no True Crime Wednesday next week. I am going to put out a list of book signings and where you can see me if you happen to be in the Pacific Northwest. You can come and get a book signed and get a hug. And I'd love to see as many people as possible, mostly because I just love to meet you all in person. I had such a great time at CrimeCon meeting so many people who follow the podcast and who follow the newsletter. And so it was really a great time. And I look forward to being able to meet more of you while we do these book signings. So I will get a post out in the community posts on the community page here on YouTube and also on our Good Lori Facebook group to let everybody know what those dates are. And I will add in some links to the web pages for the particular bookstore that I'm going to be at. So you all can join us if you can. So we're ready for some questions, Jen. Hi, Bo Peep. Is there a conflict of interest when Judge admitted that U of I was working in partnership with the court and law enforcement during the investigation? And was the U of I involved in destroying the crime scene? Okay. So early on in this case, prior to Brian Kohberger being identified as a potential suspect, I am certain that the campus college leadership, as well as campus security, along with local police, state police, probably FBI, certainly FBI, were involved in the investigation of the case. And that it doesn't surprise me that the university would be involved because these kids were all students at the university, and so it's not surprising. I don't know that it really presents a conflict, but I do think that it may present a presumed prejudice because people who are aligned with the university and were involved intimately in the investigation could be called as jurors. So I think it's not necessarily a conflict of interest, But I think that the judge, in making the decision to move, recognized that it was a presumed area of prejudice. So hopefully that makes sense. The property, the landlord who owned the property where the murder took place, gave the property, gifted the property to the university. He felt like it was never going to be able to be used for any other purpose. It could never be used certainly never be used as a residence again. He gave the property to the university to do what they wanted. But here was the problem. The problem was that at the time, there was so much interest in the property that they had to put a fence up. They had to have 24-hour law enforcement there to keep people out. They had to have private security patrolling the property. And even at that, it was difficult. It was also expensive for the university to continue to pay private security for the property. So they went, because they are now the property owners, they went to the court and said, we would like to take the building down. And initially, neither side had any objection. Now, I want to remind you that the day that Brian Kohberger was identified as a potential suspect, the day that he was to be brought back from Pennsylvania to Idaho, Ann Taylor and her team and her investigative team were in that building. They were on it. So they had all their people in the building. In addition, what they do is they have a system, the acronym for which I can never remember. They used it in the Murdoch case. They use it in many cases. They used it actually in Vallow Daybell, where they go out and they use laser measurements and they take thousands, hundreds of thousands of measurements. And from that, they build a computer designed 3D image of the property. So they had that. They had, not only did they have their own investigators, photographs, measurements, all of those things, but Ann Taylor, then they did their own independent investigation of the property as well. The families, I think, were very concerned because they were worried that evidence was going to be destroyed that might compromise the case. And they did not want in any way there to be any chance that the prosecution would be compromised or that they would be unable to bring prosecution because of the crime scene being destroyed. The judge gave permission for that property to be destroyed. I do think that there was an element of wanting to be respectful of the property and wanting to take out the looky-loo element. So I think that that was the hope for the property. My understanding is there's at least been a small memorial that's been put up there and dedicated, and probably was a healthy way for the community to move on, similar to what we're seeing now about the Daybell property. So there were a lot of arguments for taking the property down. I think that the prosecution raised concerns from the families. Initially, the prosecution said, no, we don't care. We have everything we need to prosecute the case. The defense said, we don't care. And so it was approved to be demolished. Then the families sort of express their concerns. And the prosecution came back and said, hold on, wait a minute. They reconsidered it again, and the judge decided that it was best to remove the property, to remove the structure from the property. So I can completely understand the families having mixed feelings, not wanting the, on one hand, not wanting to turn where something horrible happened to their family member into a circus atmosphere or into some kind of macabre tourist attraction. On the other hand, and not wanting the evidence to be destroyed. So I think both sides were pretty confident that the evidence wasn't going to, that destroying the building was not going to impact the case. So I think everyone's pretty confident that they can present the evidence with what they have. So, but that's a good question. And, you know, I mean, we're always second guessing. I mean, how many times have we seen people who were found guilty exonerated by DNA and new technology? And so we're always second guessing what could happen, what might happen. But I think both sides were pretty confident that they had all of the information they really needed, because they can literally produce a computer generated 3D image of that crime scene. So, can the AG step in to break up their involvement with decision making? Not sure what you're asking. Which AG and in which case? If this is a follow on to Delphi, I'm still a little confused. So say more, as the therapy sites say. Say more, Bo Peep. Ross Parajam? Guys have interesting handles. Why are 3 women in Florida all charged with second-degree murder, but all have different bonds? Boone, none. Benefield with a firearm, 100,000. Shaver plus DV enhancement, 52,000. All claims of prior DV, but without felony criminal history. Okay. You know, this is a good question. Some of it has to do with local policies. Typically, murder has no bond. I think in Sarah Boone's case, she was initially charged, I could be wrong, but I think initially she was charged with first-degree murder, which would be no bond. It is Benefield definitely had a higher bond because of the use of a firearm. Shaver, I don't know, because I really don't know enough about the facts of that case. All I really know about the facts of that case is that she alleges that her daughter shot her husband trying to protect her during an incident of domestic violence. I don't know. That's a good question, and I think I would like to delve into that one a little bit deeper. If Jen, if you would make sure that you email me that question, I will look into that further, because you're right. Bond should be relatively equal if the charges are the same and the person's criminal history is the same. Now, there are some enhancements for using firearm that could enhance bond, but it's a good question, and I'd like to look into it a little further. Now, we see that bond can be very discretionary with judges. We saw that with the Lori Vallow case, because the initial charges that Lori was brought back to from Hawaii to Idaho on were destruction, were actually, they initially were just lying to police and child abandonment. They were only one of them was actually even a felony, and yet the judge set the bond at $5 million originally. They had a bond hearing, and the bond was reduced then to $1 million. But even at that, her bond was $1 million before the kids' bodies were ever found. So, the judge has to sort of look at a number of things. In Lori Vallow's case, it was clear she'd already taken off for Hawaii and that she was a flight risk. So, because I don't know all the other details about whether or not those were considerations as well, I can look into it and see what I can find. But it is quite discretionary with judges. So good deep dive questions, though. Did we hear anything from Bo Peep about saying more? Teresa Moore. Just wanted to say I appreciate your insights. Thank you so much, Teresa. I enjoy getting together with all of you and answering questions and looking at the cases and talking about, gee whiz, why things might have happened the way they do. How can the defendant in Delphi get justice when the judge seems to be a part of the prosecution team? I think this is an excellent question. And I think that the Delphi case has gone a long way to point out the fact that judges are not always neutral. We strive for judges to be neutral. We want our judges to remain as objective and neutral as possible, but they're human beings. And we don't know whether there is anything in Judge Gall's experience on the bench or personally that this particular crime moves her emotionally in a way that maybe other crimes don't. We don't know. We don't know why she has become so blatantly and obviously biased. But I think her attorneys made a really good point in their last filings when they said, if the Supreme Court doesn't hear their motions on the use of the third party culprit and the use of the geofencing information, it's going to amount to a practice run trial because he's going to have to get a new trial. And he's going to have to get a new trial because the judge is so clearly biased. I hope that at this point, the Illinois Supreme Court is going to see, or I keep saying Illinois and Indiana and mixing them up. Bob and Allie Mata from Defense Diaries are in Illinois, and he is going to be going and attending the trial because right now Judge Gull has said no cameras and no live stream. So we're going to have to rely on eyes in the courtroom, old-fashioned wise. So Bob is going to be attending the trial and live tweeting and sending out updates as frequently as he can. So that would be really important information. But he's in Illinois, so I keep getting them mixed up. So I think that the Supreme Court of Indiana is going to have to take a hard look at that and say, we were willing to defer the last time and not order Judge Gull replaced, but gee and howdy, it's, the evidence against her being able to be neutral is really stacking up. And so I wouldn't be surprised, and I think it's very likely that this trial is not going to go in October because they're going to push their claims with the appellate court and with the Supreme Court. So, but I agree. I think that the one thing that the great deal of publicity around the Delphi case has brought out, and we've seen this in a lot of high visibility cases recently, is um, the bias of the prosecution. We trust that our prosecutors are seeking justice and that they are going to go where justice leads them, not where personal vendettas lead them, or um, where justice may not be served um, by their not making complete discovery or not making full disclosure of exculpatory information. And we're seeing those. And I think that's important because I think the public needs to see that our system, even though I think it's the best system in the world, has its flaws and is susceptible to human foibles and to influence by human beings. We're all human, and we bring to the prosecution of a case all of our past experiences, both personal and professional. We bring to a case everything that all of our baggage. And so we have to make a conscious effort not to bring our baggage with us and to try and remember that we are seeking justice, that it is not a vendetta against the defendant. It is an attempt to get justice for the victims. And sometimes I think we lose sight of that. And I appreciate the fact that these high profile trials give all of us the opportunity to look at that and give all of us the opportunity to talk about it and to bring these issues to the forefront and have a discussion about what the rule of law means. What does the rule of law mean? What does the right to a fair trial mean? What does due process mean? And it is different in every case because every prosecutor and judge and defense attorney is going to interpret it slightly different. So it's good sometimes to be a fly on the wall. Any other questions? Rosparadam, an amalgamation of my maiden and current last name and first name. Cool name. Also known as Thug Nasty from recent memory. Well, welcome, Rosparadam. And I'm glad you're with us. And it's a nicer name than Thug Nasty. Jen Dixon, any trial date update for Alexi Treviso? I have not heard a trial update. And that there was something I saw recently that made me wonder if there was going to be a plea. I would not be surprised at all to see a plea in that case. She is young. She doesn't have a criminal history. She, under a great deal of stress. I mean, yes, what she did was horrendous. And yes, it was the child's death was absolutely unnecessary. But I think that there could be an argument that she was under severe emotional duress, and all of those things, while they don't necessarily sway a trial, might very well lead a prosecutor to think, this isn't a slam dunk. The jury could look at all those factors and say, we're going to give her some lesser charge. So I think that is really a classic and really a ripe case for a plea. But we'll see. I think on the other hand, she does have a lawyer who's absolutely adamant that that baby was dead and that she didn't kill the child. And if that is the defense that they're gonna take, then I don't know of any other way than to have a trial. So, but I'll look into that. Make a note. So I'll check to see whether or not anything has been scheduled yet. There's still a lot of preliminary hearing stuff to go before I think we would see a trial in that case. So, any idea why Raw Labrador AG subpoenaed Scott Green to release records of University of Phoenix acquisition? Oh, is that in the Kohberger case? I don't know. So you might need to say more there, Bo Peep, because I don't recognize Raw Labrador's name. If you're talking about the acquisition of the University of Phoenix, if that was University of Idaho, it may be because Kohberger was okay. Yeah, it may be because Kohberger, they want to know whether Kohberger had any association with the University of Phoenix. The University of Phoenix has been predominantly online courses. And so we know that he went to college in Pennsylvania, but we don't know whether or not he did any master's work or any undergrad work at the University of Phoenix, because they do primarily online. So it may be that it doesn't have really anything to do with the acquisition of the of University of Phoenix by University of Idaho, but it may be because they want to know whether Kohberger had any history with the University of Phoenix. I don't know. I think that's going to be something that we probably will see at the trial. If those records become relevant, we'll see it at trial. What do we think we can expect in Karen Reed's next trial? Oh, it is going to be a goat rope, as they say. We can expect that the defense is going to draw and quarter. I'm trying to say something nice, something not too colorful. Every one of those law enforcement agents, they've already gotten a bite at the apple, and they know what these law enforcement agents are going to say, and they are going to be loaded for bear. They are going to come in guns blazing and be able to use their testimony in the prior trial, and go through all of the impeachment evidence. And if they testify differently now than they did in the last trial, they're going to be able to go after them. I think it is going to be brutal on all of the law enforcement. They're going to go after the guy who did the accident reconstruction, who was so terrible. They're going to bring in the FBI big guns again, and it is going to be brutal, because I think the prosecution is making a huge mistake in continuing this case. I could understand them continuing the single count that they that the jury was deadlocked on. But even that, I think, is going to be a stretch. Then when you get into the whole issue of Michael Proctor and all of the misconduct in the Canton Police Department, the swapped video, all of that, all of that can come back in. All of that can come in to impeach all of those witnesses. Isn't it true that last time you presented a reversed image in an attempt to show that nobody was near the tail light in question, when in fact they were actually in front of the tail light that supposedly hit John O'Keefe. So that is going to be one of those where you're going to want your popcorn and to clear your schedule, because it is going to be courtroom high drama. Absolutely. I mean, if you think what we saw at the last trial was courtroom high drama, this is going to be that on steroids. So we're going to, I anticipate that their defense is going to be scorched earth. They are going to go after every one of those prosecution witnesses, um, and they've got a good case. So I think if the prosecution were smart, they would reconsider. But I don't think they're smart. I don't think the elected DA could sustain reelection if he doesn't continue to prosecute the case. And we all know it's a case that's very divisive. Many people believe Karen Read is absolutely guilty. I certainly believe that the evidence that the state presented at trial did not prove it. Now, prosecutions had a bite at the apple too, and they have an opportunity to refine their case. However, you can't produce what doesn't exist. So they may be able to sort of spin their approach, but you can't make up what isn't there. So yeah, that one's going to be bring your popcorn. Do you think the Latah County prosecutor wanted to keep the trial local because of the revenue the trial would bring into local businesses? Even Daybell Vallow prosecution at first wanted to move despite the expense. I think probably not, because if you look at Vallow Daybell, the cost to the county was so much more than any individual might have realized in money coming into the community. It was crippling. I mean, um, Lori Vallow, the case before the case was severed, before the two cases were tried separately, they'd already spent almost $4 million on the case, on investigation, on housing her, on everything. So, I mean, death penalty cases are extremely expensive. And little old Latah County, I don't think that would be a decent trade-off. Yes, it might bring some more revenue to local businesses, but it would not make up for the hit they're going to take in the county coffers. So I don't see that. I think that the prosecutor wanted the case there local because it's more convenient for him. And I think he wanted it local because all his cronies are there. And he wanted it local because he believes that Brian Kohberger is guilty, and he wants a jury of that local community that have been so horribly impacted to make that decision. So, I mean, I think that's sort of a typical prosecutor stance. But this prosecutor I'm not impressed, let's put it that way. And I think he thinks he's got it in the bag. And I'm not sure that's the case. We certainly haven't seen all the evidence, so we don't know. But I have to go back to the fact that Ann Taylor has said on the record and in no uncertain terms that she and her team believe in Brian Kohberger's innocence. They're not saying we believe that we can poke enough holes or that the prosecution doesn't have sufficient evidence. We they're not saying we think the prosecution's got a weak case. They're saying we believe in our heart of hearts that Brian Kohberger is innocent. And that is not something you hear from a defense attorney very often. You hear a defense attorney say, my client is entitled to a vigorous and zealous defense. My client is entitled to the presumption of innocence. My client is entitled to due process and a fair trial. But you rarely hear a defense attorney stand up and say, I believe in my heart that my client is not guilty, innocent of this charge. And for someone who is as experienced and as detail-oriented as Ann Taylor, it makes me wonder, you know, just like jurors would say, well, the prosecution charged him, so he must be guilty. Folks like me look at that and say, wow, if Ann Taylor is willing to go to that length where she's putting her reputation on the line, she's got to know something. She is just absolutely convinced that he is not guilty. And that makes me doubt. So there you go. Before you end, I just want to thank you, Lori. I've learned so much from you, and I value your experience and how you break it down. Thank you, Bo Peep, because I know I'm not the only person you watch, because I see in the chats on other people's channels, because I watch them too. You know, we can't all be everything to everybody. And I love the creators who feel like this is a big tent and we all have something to offer. I love those creators and I am happy to promote them. That's Bob and Ali Mata, that's Joel Waldman at Surviving the Survivor, that's Andrea Burkhart, and a lot of other folks that you see me talking about and are in our chat. This was never meant to be a money-making proposition for me or a career. It was meant to be a platform to interact with audiences who might be interested in my book. So I'm super excited. The clock is ticking down, and it is exactly 12 days. I have to get my little calculator on my phone until the book hits the shelves, and I'm super excited. I'm very proud of it. I've seen a few. By the way, I want to thank everybody who has already posted reviews on Goodreads. You can post your reviews there if you like. Amazon doesn't allow reviews until the day the book drops. I am trying my darndest to get 60 Amazon reviews, because then we end up in the algorithm where the book would be recommended to people who have read or bought other true crime books. So I would love to get there. But, you know, I love the medium. I love being able to interact and chat with you all. It's like CrimeCon once a week where I get to visit with people who are like-minded. And I thoroughly enjoy doing this. And so I appreciate that we are not the biggest community in the world with 8,000 or a little more than 8,000 subscribers. If you're not subscribed, please subscribe and hit the notifications. I appreciate all of you who have been subscribers for so long and have been along this journey with me. I enjoy it so much. That's what keeps me coming back on Wednesdays. Is I get to work my brain out a little bit and think about cases and chat with you all. And it's always a delight. Our community is not large, but we are probably the best chat going. Always respectful, always thoughtful, always asking good questions. And so I appreciate you all. I'm going to say goodnight because I need to go pack a bag to go to Vegas, baby. And I will get a schedule out as soon as I have one. But we won't be having a live next week. We likely will have a live the following week, but I'll be doing it remotely from Portland before the book signing. So let's all have a great week next week. And I will see you all in a couple of weeks. Good night.